Okay, so Ms. Dugas is on probation for the offense. Hold on, let me put it on. Of robbery, a second-degree felony. We were previously here, and she entered pleas of true to counts 1 through 12, all is in that motion, second amended motion to revoke unadjudicated probation. I received the updated pre-sentence report as well as a letter from Ms. Dugas. Has everyone had an opportunity to review that?
Yes, Your Honor. Yes, Your Honor.
Are there any additions or corrections?
None from the defense, Your Honor. None from the state.
All right, and this was unagreed, correct?
It was a cap. Cap of 8.
Ms. Holmes, you may proceed.
Thank you, Your Honor. I've spoken with Ms. Dugas. Obviously, the very new offenses and violations is not acceptable through probation. She understands that. She stated that throughout this time, she did not have much support. She was going through a hard time in life, and she resorted to doing and committing these offenses, not being in obviously the right state of mind to be able to successfully complete probation. Ultimately, Ms. Dugas is requesting to have the opportunity to be reinstated to complete probation, and she would like to address the court in regards to this as to her plan of how she can successfully complete if given the opportunity.
Okay, go ahead.
How you doing, Ms. West? I'm wasting your time. When I get out in the world,
Speak up.
when I get out in the world, I'm going to do everything in my mental power to complete this probation. I know it's going to be extended if you do grant it to me. By getting me a job, staying out the way of bad company, being a better mother, being there with my family more often.
Ms. Dugas, you did the exact same thing. You robbed someone else while you're on probation for robbery. Not just robbed someone else, you failed to ID, failed to report to probation, you committed the new offense of possession of a controlled substance, you resisted arrest, it's ridiculous to me that you're saying you want a second chance, because this was your second chance. You've already been on probation. You were given the second chance of not going to prison. The fact that Ms. Holmes negotiated a cap of 8 years for you, you should thank your lucky stars. This is ridiculous. 8 years, in my opinion, is not enough. You had every opportunity to do all the things that you're taught. Stop crying, because you weren't crying when you were people and using drugs and not being a good mom and not doing the things that you should have done when you were given this opportunity. Right?
Yes, ma'am.
Ms. Malfino? Sorry.
I don't think I need to add anything to the report. I think if you recall the agreement that 8 at the very least is appropriate for her based on the number of violations. I spoke with Mr. James yesterday. He does not want to continue to work with her. This is actually her third MTRB, so it's about her 5th chance in front of you, not just her second chance, and I think we're for this purpose.
Ms. Dugas, I'm going to find that you entered your pleas of true to counts 1 through 12 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time, find you guilty of robbery. I'm going to sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes. I hope you take some advantage of this and actually do what you're saying you're going to do when you get out and change your life. There's programs in prison, take advantage of them, but you're not going to continue to get opportunities like this. If you continue to violate the law after this, you're going to be considered a habitual offender. And if you do anything again, your minimum punishment is going to be 25 years. 25 years minimum for what you've been doing. So you need to change your life or you're never going to see your kids, right? Go back with the bailiff.
Judge, would the court be willing to entertain a concurrence so that we would have that
Yes,
individual
yes,
down
ma'am.
the road?
Yep, if y'all want to get that taken care of, that's fine. Brianna Williams, Mr. Parker.
Correct. There is
Okay.
a condition one that gonna handle in this minute.
Okay, so you'll abandon that in this motion?
Yes, sir.
Good morning, are you Brianna Williams? And will your client, well, Ms. Williams, before I go any further, the best you can, raise your right hand, please, ma'am. Do you swear affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Mr. Parker, will your client waive the formal reading of the motion?
Sure, Your Honor.
Ms. Williams, in cause number 18-30512, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation May 20th of 2019 for the offense of injury to a child, and that was a 10-year deferred probation. Is that correct? Count 2 alleges that you provided a urine sample November 19th, 2024 that tested positive for tetrahydrocannabinol. And is that true or not true? And count 3 alleges that you were at a location other than your residence at approximately 11:53 p.m. on November 11th of 2024. And is that true or not true? And then finally, count 4 alleges that you're behind in your court-assessed fees. And is that true or not true? Did you enter your pleas of true to counts 2, 3, and 4 freely and voluntarily? And because they're actually true. I have some documents here on the computer that you've signed with Mr. Parker. Did he go over these before you signed them? And you understand if I go along with this and continue you on probation, you won't have any right to appeal. And it looks like what the agreement is for me to continue you on probation, order that you do the 30-day program at the Franklin House. You will be, my computer's stuck. There we go. In addition, you'll be on the high-risk caseload through MHMR, which will give you all the tools, hopefully, that you need in order to be successful and make better decisions. Do you understand? I want you to know that if I go along with this and give you the opportunity, it sounds like probation, everybody wants to work with you. You need to do everything you're supposed to, because if you're back in here again, you probably will not get the same opportunity, okay? So I'm going to find state tenders number 1.
No objection.
It's admitted. Any evidence Ms. Williams isn't competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 2, 3, and 4 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to follow the agreement, continue you on probation. I'm going to order that you enter and successfully complete the 30 days at the Franklin House. You will be on the high needs caseload so that you can get any help you need and follow all of the rules and conditions of probation. Cannot use marijuana. You cannot be out of your house. You need to do everything you're supposed to, okay? This is your second chance or third chance. It's time to make sure you do everything correct, okay?
Your Honor, I'd like to represent the court. She has done all her classes where she can become a pipe fitter or some other jobs that pay good, and she's actually requested that she needs some type of therapy, which I think MHMR will help. And so she
Perfect.
requested on her own, and she's wanting that.
Well,
So I
and
think
that's
it's
when
a
it's going to
positive
work,
attitude.
that's when it's going to work the best, is when you know you need some help getting through some things, take advantage of the help, you're going to get it, and that way you can go on with your life, hopefully get that great job, and this will all be behind you.
If you need help, ask the probation. Don't be scared of them.
Yeah, don't be scared, they're there to help you. Ask ahead of time, don't ask for permission, don't ask for forgiveness. Does that make sense? Okay. I'm handing you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. Good luck to you.
Just remind the court, you might want to remind Mr. Millhouse about the court order regarding the photo.
Oh, yeah.
Good morning, Ms. Young.
Good morning, sir. You are Joshua Barlow?
Yes, ma'am.
This is cause number 18-26688. Mr. Barlow is on probation for possession of a controlled substance. A motion has been filed. What is the announcement?
Judge, we did a short reset on this one because we had a court date out in Harris County. Was in hopes that they would go ahead and dismiss that one then, but it looks like we will be moved to the trial docket. I believe they're going to try to subpoena the complainant over there. And so I don't know how long it's going to be or when.
But it's
That's
understanding for Mr. Lewis, and I have no reason to doubt that based on my knowledge of that offense, Mr. Barlow, et cetera, that their subpoena of her will be against her will. And I don't intend to proceed on that with the court's permission in the motion under those set of circumstances, Judge, if that makes sense.
Right, and so do we, what are the other allegations? What's the?
If we could maybe at this juncture, knowing that, if we could just abandon or bypass those at this moment and have them enter pleas of true or not true just to the administrative violations, maybe get an update, see if there is for some reason any change in that before I formally abandon it. But it is my intention and it is my understanding based on the facts of that case that there's a subpoena of her, and correct me if I'm wrong, it's probably against her will.
Right.
Over there, I mean, are we going to wait 3 years for him to go to misdemeanor trial?
No, we're doing it here, and if
Right.
you want to get her here or try, that's one thing. If not, we're not waiting on that. So let's go ahead and go through the motion and get pleas of true or not true, and I will, it looks like, skip number 1, number 2, just those 2. It looks like I have to do with that other case. Okay. Mr. Barlow, raise your right hand, please, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, sir. And will he waive the formal reading of the motion?
You would, yeah.
Get this done real quick. Hold on, sorry. All right, Mr. Barlow, in cause number 17 26688, I have a motion to revoke your community supervision. Shows that you were placed on probation September 18th of 2017 for the offense of possession of a controlled substance, a second-degree felony. Now, it was a 10-year term in prison that was probated for 10 years. Is that correct?
Yes, ma'am.
It alleges you violated your probation. Count 3 alleges that you failed to remain in Jefferson County as ordered and that you were in Harris County, Texas, November 8th of 2025. And that was without permission of Jefferson County probation. Is that true or not true?
Yes, ma'am.
True or not true?
True.
Count 4 alleges that you failed to immediately report to the Community Supervision Department an up-to-date physical address. And is that true or not true?
That I didn't.
That you didn't tell them a new address
It's not true.
where you were living? Okay. Count 5 alleges that you failed to immediately report to the probation department your arrest from November 8th of 2025. Is that true or not true?
True.
Count 6 alleges that you provided a urine sample March 4th of 2025 and April 8th of 2025 that tested positive for tetrahydrocannabinol. And is that true or not true?
Can you say what?
Marijuana.
Oh, true.
Count 7 alleges that you're behind in your court-assessed fees as of November 19th of 2025 in the amount of $4,734. And is that true or not true?
True.
Did you enter your pleas of true to counts 3, 5, 6, and 7 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
All right, then I'm going to find that you entered your pleas of true to counts 3, 5, 6, and 7 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, but I'm going to reset your case for a sentencing hearing. We'll get an updated pre-sentence report, find out anything else about those cases in Harris County, and then we'll come back at that date for sentencing. Are you currently wearing a drug patch? Are you ordered to wear a drug patch? Before you leave today, I want you to have a seat in the jury box. We're going to get a drug test this morning. All right, have a seat. Actually, come over here first and get a thumbprint, and then have a seat for a drug test.
Yes.
Good morning, ma'am. Are you Brittany Davis?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
She does.
Ms. Davis, in cause number 25, DCCR 1450, you're charged with the second-degree felony offense of assault on a peace officer, and that's from May 19th of 2025. And how do you plead to that charge?
Judge, it is a reduced charge.
Oh, I'm sorry.
Yes, Judge.
Y'all gotta
Sorry.
stop me before I get too far. Hold on a second. All right. It's pulled up right now. All right, so Ms. Davison, cause number again, 251450. The state's elected to proceed on the lesser included offense of a Class A misdemeanor resisting arrest, and that's for May 19th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement is for a 1-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
And are you a U.S. citizen?
Yes.
State offense number 1.
No objection, Judge.
It's admitted. Is there any evidence that Ms. Davis is not competent? All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 1 year. You're ordered to pay that $500 fine and to follow all of the rules and conditions of probation. If you do that, this is a great opportunity because you have a conviction on your record. And at the end of the probation, if you successfully complete it, the case will actually be dismissed and you'll never have the conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, you could be found guilty of the offense, and you could be sent to the Jefferson County Jail for up to 1 year. Understand? All right, I've handed you the trial court certification that shows you've waived your right to appeal since I followed the agreement. You need to stop and talk to probation or have a seat in the courtroom until she's ready to call you up. She's at that desk right there. So just watch for her to call your name. She'll go over your paperwork with you. All right. Bless you, ma'am. Thank you.
A courtroom filled with emotion, broken trust, and final warnings became a powerful reminder that second chances do not last forever. One woman on probation for robbery stood before Judge Raquel West after committing more crimes, failing drug tests, resisting arrest, and violating nearly every condition she had been given. Despite her tears and promises to change, the judge made it clear that probation was already her second chance, and she had thrown it away. Another defendant received mercy after admitting mistakes and agreeing to strict treatment programs, while others faced drug testing, sentencing hearings, and probation violations that could completely change their futures. Throughout the hearing, Judge West repeatedly stressed one message: accountability matters more than excuses. Some defendants were offered one last opportunity to rebuild their lives, while others learned that repeated bad decisions eventually lead straight to prison. And by the end of the courtroom session, one truth stood above everything else. Every choice leaves consequences, and eventually the law stops giving warnings and starts giving sentences.